Hello, YouTube. I'm Vince White. I'm an employment attorney. And on this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question here from YouTube user Greatness664. The Greatness. It's an impressive name, impressive username. And Greatness664 asks us, how do you explain a situation whereby a self-represented person loses a case? They then get an attorney to appeal. The attorney makes the same argument as the client and wins. Okay, so there's two flattering answers here for the pro se litigant in this hypothetical. The first one is the judge, jury, whoever it is in the lower court that was overturned on appeal just got things wrong. That happens, right? You can make the best argument. You can have all the best arguments, and you can lose. That's inherently the issue with our legal system. I don't see any way around that issue. But if you have a finder of fact, if you have a decider, right, for a case, that person could make a decision that is wrong or stupid or makes no sense, right? And that happens. And when it goes up to the appeal court, the appeal judge might just say, yeah, that was wrong. And that's how this happened, right? It doesn't necessarily mean that anyone was ignoring the pro se litigant or anything like that. It just means the lower judge got things wrong. And that happens. It happens to pro se litigants. It happens to attorneys. Although I will say it happens to pro se litigants at a far higher clip than it happens to attorneys in my personal anecdotal experience. Now, the second flattering thing that may have happened here for the pro se litigant is that everyone involved in the practice of law tends to ignore pro se litigants because they have been taught by long experience that pro se litigants outside fields like landlord-tenant court or small claims court, outside those fields where you have a lot of pro se litigants and they can generally represent themselves very effectively, or at least mostly effectively, somewhat effectively, and those are fields that are streamlined for pro se litigants, right? They're built so you can represent yourself a little bit more. But outside, those fields, especially as you get into complex litigation, which employment law very much is, right? I would list employment law as one of the most complex of the plaintiff-oriented litigation fields. So as you get into the more complex fields, pro se litigants tend to be one of two things. And I understand, I'm not insulting anyone here. I know there's lots of pro se litigants on the channel. I'm not mocking you. I'm not deriding you. I'm saying this is a tendency for pro se litigants, not the rule for pro se litigants. All of you, I'm sure, are wonderful. Although I will note that there are people in the comments on this channel who very much personify what I'm about to say. There is a tendency for pro se litigants in complex litigation fields to just not get that they don't get it. Like, they don't understand what they don't understand. Or often they are just unwell, mentally unwell. And that's not to mock them. They're dealing with a mental illness, or so it appears. I'm not a doctor. But anecdotally, every judge, arbitrator, court attorney, court clerk, defense counsel, even plaintiff's counsel will tell you that, if you're dealing with a pro se litigant in complex litigation, there's a decent chance there's something impairing that person's ability to properly litigate the case. Just a reality. Now, that is not the rule, but it is a tendency. And that tendency teaches all the people I just listed to not listen to pro se litigants. Because when you do, it just doesn't make any sense at all, or they're vomiting hate or rage or whatever it is, right? That's very, very common. And again, there's people on the comments on this channel who just type the law says this, and you're like, I'm not sure you can. I mean, you can write, but can you read? How is it that you can write? How can you type the text if you can't read? Because if you could read, and it appears you've done a lot of research, but it doesn't appear that you've understood, that you've grasped, that you've digested. Perhaps the word is grokked, right? Grok. Did you truly grok the meaning of what you read? to reference stranger in a strange land, right? And so here, our hypothetical pro se litigant, I'm sure, didn't do that, but may have suffered from the fatigue of everyone in the complex litigation industry when faced with pro se litigants, and they may just simply have listened to this pro se litigant, right? And those are the two most flattering answers for the pro se litigant. Remember, and I've always been very clear on the channel, and I say this with love because I know there's many of you out there who are pro se litigants. Being a pro se litigant in a complex litigation field, especially employment law, is merely an act of self-loathing and self-harm. The end. It is what it is. You can get mad that I said that. You can tell me I'm doing an amazing, and you might be, right? Like, listen, there have been people on this channel who did a great job. There are other YouTubers who did a great job pro se for most of the way, and just brought in an attorney for the trial or what have you, right? Fight Employment Discrimination, the YouTube channel, was pro se for most, I believe, of the process, and did amazing. And every time I reference that, I do make the joke that, she's basically a rocket scientist, right? Like that, a lot of horsepower, a lot of intelligence there, right? If I didn't work in this field, I'll tell you right now, I couldn't just walk into this field and start representing myself any more than I could walk into a sealed engine bay on a brand new engine and just start fixing it. Nope, couldn't do it. Don't know the first thing, wouldn't, and it would take me years to learn even the basics, right? So I'm not deriding the pro se litigants. I'm just saying, this is an issue. Now, the less flattering possibilities here is that, listen, the pro se litigant may be communicating in a way that is perceived to be aggressive. Very common. Pro se litigant may be communicating in a way that is perceived to just not get it. Very common. Pro se litigant may be communicating in a way that is perceived to be unwell. Happens a lot. Pro se litigant may think she or he is communicating in a way that conveys a completely thought out argument. All the elements included, all the factual underpinnings, a narrative that holds together, that not only makes sense, but is also compelling, right? And that may not be the case, right? The ability to hear one's own argument and say, yeah, that needs work, I've noticed, does not live in most first-year associates in this field, right? They'll come in and be like, here's my argument. And you're like, okay, I see where you were going. You're on the right path. That did suck. And you're not going to make that argument because we like our clients, right? And I'm kidding. The first year associates here are amazing. But as you're training, you have to teach and edit. And part of what you learn is you need to hear the argument you're making critically. Not with love in your heart for your own words, right? That's not what we do. We hear our words and we say, those were some words that were great. And maybe some of the other words could have been better. And that's how we get to the most compelling narrative possible. The best argument, right? It's a process. It must be edited. It must be refined. It must be practiced. It is not something that you can just necessarily, and listen, everyone's different, but you might not show up day one on your first case ever without a lick of training and just start spouting off the best shots, taking all the best, odds are that might not be the case. So it just might be that the pro se litigant didn't communicate what she or he thought they were communicating, or didn't understand all of the things they needed to argue, or, often assumed some factual leaps into the argument. I see that all the time. And there's no guarantee that your audience will follow you on these factual leaps, right? That's something you have to remember. And it's also something that I'll tell you right now, a good attorney will notice if they think they're losing their audience. And they'll circle back and say, hey, I feel like I lost you somewhere around turn 3 in the argument. And I want to just go back there and make sure we understand that at turn 3, we said this. And now we're over here because that makes sense. And you might get them to come with you this time. Right? You might. But if you don't try, you sure won't. You already lost them. Right? So all these things are going on. It might just be, listen, the attorneys get a lot of repetitions. They do this over and over and over again, presumably. It's their job. It's what we do. And practice, well, I don't think it makes anyone perfect, but it certainly does act to perfect. It makes things better. It makes you quicker. It makes you more able to have time to think as you're making your argument. Have time to watch your audience. To have thoughts about, are they with me? Do they follow? Do they agree? Have I made a leap that didn't logically follow? Did I say are all the elements accounted for that I need to prove in my argument, right? And that practice can lead to a more compelling argument, a more compelling narrative. It's just the reality. So Greatness 664, I've given some flattering and some unflattering possibilities here, none of which are really that unflattering, frankly. I wouldn't say anything I've said, even if you're dealing with a mental illness, and I'm not saying you are. That's not unflattering. Listen, I am positive that there's probably no human being walking around who doesn't deal with some form of mental illness that could be treated to better their life, right? So that's not like, I'm not deriding anyone. I'm just saying it can be hard if you're dealing with something like that, occasionally, depending on what you're dealing with, to convey things in a high conflict, combative, high stress environment. And it all depends on the diagnosis, right? Like most diagnoses would probably have no impact. But there does seem to be a tendency in pro se litigants to have a very difficult time with some forms of conflict. And it can bring out aggressive or unpredictable tendencies at times. I hope this helps. Greatness 664. I love pro se litigants, and I want to see them succeed, and I don't mean to dissuade anyone. I just also have to be honest. It is an act of self-harm. Being a pro se litigant in a complex litigation field is merely an expression of self-loathing. You hate yourself and your claims, and you would like to harm yourself and your claims. The people who do it and succeed, demigods. I don't know how they do it. It's incredible. I am so deeply impressed. So deeply impressed by those human beings. But incredibly rare. Incredibly rare. There's been people on this channel. There's been people who watch this channel. I mean, they've really done it. Really done it. Like, whoa. I hope they go to law school. I hope they become employment attorneys. I hope they apply to me for a job, right? Like, super excited to work with that person. But they are the exceptions that prove the rule. Pro se litigants generally are just yeeting away their claim. Just throwing them away. Throwing them in the trash. I wouldn't even say 9 times out of 10. I would say 99 times out of 100. In my anecdotal experience. That's just what I see. And it makes me sad. It bums me out because I want people to get paid. I want people to be made whole. I want employers to be on the run for what they've done when they've done bad things. And, yeah. So I hope this answers your question, Greatness 664. I suspect the simplest answer is people just weren't listening because that individual was pro se, and people tend not to listen to pro ses. That is the simplest and most likely answer to my mind. Like, subscribe, comment down below, share the channel to help it grow. Take care, everyone.